Welcome back. Many in the state paused midday Thursday to see a guilty verdict rendered for the murder of Harmony Montgomery, a 5-year-old Manchester girl last seen alive in 2019, but not reported missing until 2 years later. Harmony's murder was yet another unfortunate example of a case in which a more timely and effective intervention from state officials may have saved an innocent life. Those kinds of cases are the reason why New Hampshire created an Office of the Child Advocate a few years ago. And this morning, we have the Child Advocate, Cassandra Sanchez, with us in studio. Ms. Sanchez, thanks for being here.
Good morning. Thank you for having me.
So first off, your reaction to that verdict in the Harmony Montgomery case?
Glad to see the court system hold Adam accountable for his horrific actions. It's mixed feelings, though, really, at the end of the day, because none of that is going to bring Harmony back. Any of the children that we've lost in New Hampshire, even the work that the office is doing, none of that brings these children back. And so for us, the critical focus is really how do we work with our system and those key stakeholders to continue to make changes that are going to improve the way our system works for our children that are here and to avoid these tragedies in the future.
Mm-hmm. And obviously there were some extraordinary circumstances in this case, the COVID-19 pandemic, and of course you had Adam Montgomery going through a long and gruesome ordeal of trying to hide this body, essentially a long and grisly cover-up. There were so many off-ramps, though, to potential intervention for Harmony. As a watchdog agency, what is your level of confidence that the state can prevent similar circumstances from happening in the future?
You know, it's difficult. There were so many circumstances of this case that are different. Every case is really unique and different, but so many circumstances. You include the cross-border child coming from a system in Massachusetts, being transferred to New Hampshire. There's just so many complicating factors that we can't say as the oversight agency that we can absolutely prevent these things from happening, but the work is there. The folks that have the ability to help make those changes in the system are on board with those changes. It's talking about our legislature. That includes the leadership within our DHHS entity, for many law enforcement agencies willing to come to the table to have these conversations about how do we partner better in these cases. So that's key. So we have the interest in improving our system. It's just making sure the steps that we are taking are actually effective and are protecting our children.
Something we learned in the course of this court case, obviously, DCYF went to investigate an allegation of abuse against Adam Montgomery, that he hit Harmony and gave her a black eye in July 2019. The state's 2022 report on the system breakdown said, quote, an assessment was conducted and Adam Montgomery and Harmony as they were entering their vehicle. So he was basically running away as the CPSW got there. But at trial, we learned from that CPSW that he saw maybe just 10 to 15 seconds worth of a girl that he could see from 30 to 40 feet away. Couldn't really even get a full ID at that distance. But he told Manchester police he didn't see any injury consistent with a black eye, even though he was so far away. Mm-hmm. It seems like that might have been one of those inflection points that could have off-ramped this situation from becoming fatal. What is your opinion of how DCYF handled that situation?
Again, it's a difficult question to answer. It's really hard to look back and say they should have or could have done this differently, which is why we, as the Office of the Child Advocate, use a very unique review system when we review these type of cases with the agency. We focus on safety science, and so it's not looking at that specific worker and saying, what did they do wrong that they could have done better? But it's what policies or procedures or barriers exist in the system that don't allow for thorough checks to happen. We know at the time that caseloads were really high. So focusing on those issues, how do we ensure that caseloads are coming down, that there are enough staff in the field, that there are enough touch points with children per policy that tells them they have to lay eyes in a certain way and in a certain format with a child. And so that's really our focus, because it really is hard to look back, although that worker can recall in the moment what was happening for them. I'm sure there were a lot of other external factors that also impacted their ability to do their work. And I've seen so many times in this case where it's quick to point the finger at a specific person or a specific agency that didn't do something correct. But there's so many entities involved in the protection of children. It doesn't fall on one sole person.
Do we know if DCYF still allows a momentary encounter like this to count as an assessment?
No, there have been improvements to policy since that time. And the improvements do include making sure that they are sitting down and observing the child, that there is a body check if they are to be looking for bruises, if there was an allegation of physical abuse, as well as really amping up the policy around locating a child if a parent is saying, well, now they've been sent to the other parent somewhere else. They have to do more intensive checks. They have to be reaching out to, if it is, for instance, out of state, like in this scenario, they have to be reaching out to the state agency asking for for courtesy assist to go to that home to verify is that child there. Law enforcement courtesy assist as well. That didn't exist in policy prior. So we have learned a lot, and a lot has changed within our DCYF agency as a result of what occurred for Harmony.
And you mentioned the finger pointing. A lot of that happened across state lines between New Hampshire and Massachusetts. The lines of communication, there's been work done to improve those. In your view, are those lines open and effective right now?
It's gotten a lot better. There's still work to be done. There always is, because there's policies state to state that differ, laws that differ, and so they do put up barriers in place. It has improved drastically with Massachusetts, but I think both of the states have learned quite a bit from this case. But we don't only neighbor with Massachusetts. We have Vermont and Maine, and so we need to ensure that we have those lines of communication open with all of our bordering states, and even beyond that, all the states in New England, because it's such a small regional area. It's very easy for families to move from state to state and information not follow them.
And your counterpart in Massachusetts said one of the factors working against Harmony's safety was, quote, unequal weight placed on parents' rights versus a child's well-being. Now, in the New Hampshire House, we know there's a special committee that's starting to meet now, not looking at how to better protect kids. There's already committees for that, but to delve into whether parents are receiving adequate due process when an allegation of abuse is made. What are your thoughts on this?
We are going to be tuning in. We will be watching very closely, and if we have an opportunity, we would be happy to speak up on the importance of ensuring that children's best interest is at play and equal footing as parental rights. It's critical. It's a lot of what is in some of the other legislation that we've worked on this session, is really ensuring that we are looking out for our children's unique needs when placing with a parent. We did some work this session on Senate Bill 417 that has some language in there about parental fitness for a non-accused parent. Unfortunately, this case didn't fit perfectly in that because it was the state of Massachusetts that gave Adam custody, but we don't want that to happen in our court system, so we want to ensure that our courts are asking more questions, and that's some of the language in that bill, is ensuring that they're asking more questions, particularly about the child's needs and the parent's abilities to meet those unique needs.
Let's shift to another case you've been on top of since last year. You've been trying to get more accountability in the system when kids who are in the juvenile justice system end up in out-of-state placements in residential facilities. Yes. Obviously, this started with the Bledsoe Youth Academy in Tennessee, where you went there and said that there were 2 young men in this facility that was not acceptable in your eyes. You described it as a, quote, horrifying situation. What needs to change in the law to make sure that doesn't happen again?
Thank you for asking that question. We have some great legislation this session that's looking at exactly that. It's really around the oversight of these out-of-state placements and really our children residential overall. So there is Senate Bill, some of that language is in Senate Bill 417, where it really talks about priority of placement, reducing children placed in residential whenever possible, and when they are, really focusing on, first of all, if they can remain with relative care. That's what we understand is best and leads to best outcomes for children. So ideally, we'd like to see that first. If it's not possible to maintain them in the community, if they have higher level needs that need to be met in a residential setting, really seeking out a setting that is to meet their needs, and there is a very short time frame to getting treatment and then returning back to the community, so our children aren't lingering in care unnecessarily and at risk. We have also worked on House Bill 1573 and looking to bulk up some court oversight in that bill, ensuring that the courts are asking a lot of questions about these residential placements, that they're understanding that whether they are meeting that child's needs or not. In that, also ensuring that DCYF, when they are going out to meet with children in these facilities, that they are doing thorough visits of a facility similar to what they would do with children in foster homes. And unfortunately, that's not what we found in Bledsoe. They had been out there 7 times prior, and they had not raised the level of concern that we did when we got out there. And I can tell you that it did not drastically change because they had been there just weeks prior to we were. So the facility did not drastically change by the time the OCA got there. And so it is critical to move forward with these bills and really ensure that we have stricter oversight, that our courts are involved in that process, and that we're not leaving our children in placements that are not meeting their needs, and specifically those that are going to further traumatize them.